Okay. Jefferson County Court, law number 2 is back in session. The court is in session and cause number 23CC-CV0214. The case is styled in the state of Texas versus Anthony Ray Gillen. Mr. Gillen is represented in this case by his attorney Brian Lane. Mr. Lane is present in court, and the state is also present in the court. Mr. Lane, you filed a motion to dismiss the judgment Nisi and set aside the bond. Is that correct?
Yes, sir, Your Honor.
And are you ready to proceed?
Yes, sir.
On your motion?
Yes, sir.
State, are you ready?
Yes, we are, Your Honor.
Okay, Mr. Lane, you may proceed.
Thank you.
Now you're proceeding with the argument?
Yes, sir.
Okay.
I think that the court, last time we were here, took judicial notice of some of the file. In this particular case, that was the bond. That was also the bailiff's call and some other things that we were dealing with as far as moving forward with the judgment Nisi. The judgment Nisi is basically a lawsuit against two people. It's a lawsuit against the principal, Mr. Gillen, and the surety, which is me, Brian Lane. And the court, after taking judicial notice of some of the things that the state was intending to introduce to prove up its judgment Nisi, stopped at my request to allow me to present the motion that I have today, because I felt there was a valid problem with the bond and how it relates to the judgment Nisi. So that's kind of where we are. So what do I think that the problem is? Well, if the court will take a look at the bond, this is kind of a nutshell.
Hold on. You're gonna have to go to the criminal case number. You need.
Your Honor, if it's all right with the court, I'm gonna go ahead and go up to the bar.
Yes, y'all can come on out. Print it off. You have a copy of that bond?
Well, that's what I have one, but I've already marked it up, Your Honor.
Yeah.
Um,
Okay, she's gonna print another one, 2 copies. Thank you. Here you go.
okay. Yes,
Okay,
I've
now,
got my copy.
Mr. Lane,
Yes, sir.
you making mention of the bond?
Yes, sir. Now, what I did in my motion to dismiss the judgment Nisi is I separated out 2 separate principles of the bond. See, the bond is quasi-criminal and quasi-civil. In other words, it's a civil contract. That's how the sheriff and the state gets to its judgment Nisi, to sue. So what you have in a bond, in our bond, is you have an appearance section and you have an oath to pay. That's the contract section. And that's how bonds, most of the bonds in the state of Texas are written. They have an appearance section. Why? Because it's a criminal charge if you don't appear. They have a contract section because if you don't appear, then you may be liable for the amount of the bond, and therefore a judgment nisi can come against you. So the bonds are separated in this way. Well, my basic premise is that if you're going to, under the civil contract, that is the oath part, that you have to have the principal with the oath. In other words, the contract part of the bond is the oath. Now, what you have up here is you say, well, this is on the top part, the appearance bond. Say, oh, well, this is an oath. That's not an oath. That's not an oath pursuant to the Code of Criminal Procedure. You know what this is? When I get a notary, the court knows whenever you notarize someone's signature, the notary saying that's the person that signed. Here, you signed my book. That's you. I'm notarizing that you are the person. Your brother didn't sign it. Your mother didn't sign it. You signed it. I notarized that that's you, and I can come to court and say that's you. That's not an oath. An oath for what? That is a promise to appear, but it's not an oath to pay. So what has happened is the particular oath to pay to be bound under a judgment nisi requires the principal, like a car. I'm going to go and step in for my son. He's an adult. And the son becomes the principal. I become the surety. Now we step into the contractual part of the bond, not the appearance part. The appearance part is the top part. The oath part is the bottom part. Well, what this particular bond does, and I know this is a bit of a proffer, and so I guess we'll see what the state says. I wrote a bond for an individual long time ago. It was out of Bell County. It was for a friend of mine. I get to Bell County, the bond gets to Bell County, and Bell County says, your bond's insufficient. Why? For the appearance? No. For the oath of it, that you can't prove or we can't get money from you if you don't show. They literally denied the bond, filed a motion, and the judge rejected the bond. Was making my client sign a new bond, one of their bonds. Why? Because the oath in our bond does not require the principal. So the contractual part of our bond doesn't require the main person to sign. And I kind of put that out in the state has a lot of legitimate arguments when it comes to sufficiency of the bond, but my main argument is the sufficiency of the oath. You cannot get to the judgment nisi without putting the principal and the surety under oath, binding them to an amount that they're for. Now, the bond up here, the first sentence in the appearance sections says are firmly bound. That's not an oath, and that's certainly not signed by the principal. The oath comes and it says oath down at the bottom. Well, the oath of the principal is included in the surety oath section. The section provides the statement that the principal and the surety swear it are worth a certain sum of money after deducting the property and everything else. So, in other words, the principal actually is the one that has to sign under oath. So, the trial court can't legitimately take a bond or pursue or be allowed to pursue in a judgment nisi where they did not sign under oath affirming a financial worth. In other words, the state says, or the argument is, look, the top part of this is the oath for the principal, and the bottom part is the oath for you, and we've kind of done exactly what the Code of Criminal Procedure says. You've done exactly what the Code of Criminal Procedure says for appearance. You have not done exactly what the Code of Criminal Procedure says for liability. See, there's two sections, the criminal section and the civil section. And our argument is that the liability under a judgment nisi is not present when you don't have the right oath. So the principal should have also signed under oath that they are worth a certain amount, live in a certain county, and that's what the Code of Criminal Procedure under 22.02 and 2213 requires, that the principal sign an oath. Now, if the principal does not sign under oath, go back to a car case. If my son doesn't sign as principal on the contract under oath that binds him, then of course you can't bind the surety, because the surety can't be bound if the principal is not bound. So at the end of the day, if you don't have a legitimate principal, you can't have a surety. And that's where 2213 basically says that, Code of Criminal Procedure. If you can't bind the principal, then you can't bind the surety. So that's our argument in a nutshell, is that for purposes of a judgment nisi, not for purposes of appearance, purposes for maybe bail jumping or bond forfeiture, but purposes for a lawsuit, that this bond does not place the principal under oath and therefore is insufficient to prove up a judgment nisi, and cannot bind the surety without first and also binding the principal. And so that's basically what.
May I respond, Your Honor?
Yes.
First, I would note that Mr. Lane only cites 4 sections of the Code of Criminal Procedure. None of these codes of criminal procedure supports anything that he's argued here today. Absolutely nothing. In fact, they contradict what he says. And before I get into that argument, actually the Code of Criminal Procedure presumes that if there's any problem with the bond, the nisi, or the judgment, that under 2212, and I've cited this in my paragraph number 2 for the court, it says that the bond, the judgment declaring the forfeiture, the citation and return thereupon, and all the other stuff that's in there said, shall be amended under the direction of court. So had there been a problem with the bond, and Mr. Lane is submitting a document to a governmental entity for purposes of getting someone out of jail, and now he's arguing that that's an invalid document, that's questionable in and of itself, but it provides for reforming the bond, the judgment nisi, or whatever needs to be reformed. Frankly, as I'll point out in a minute, there's nothing to be reformed simply because the bond is valid. This is the bond that's used by Jefferson County and has been used by every attorney that's bonded somebody out for as long as I've been here, and that's been 7 years. So anyway, that's the first deal, is a reform, not granting of a dismissal and of the judgment nisi or setting aside the bond. The next issue, and this gets into the under oath, and I, for the life of me, cannot understand what in the world Mr. Lane is talking about at all. Right here, Your Honor, and I've got it highlighted. That's the notary seal. It says subscribed and sworn to me by the principal on this day. That's what that says right there. I mean, his saying that it's not under oath. What does sworn mean if it doesn't mean under oath? And in fact, I've got case law in here that I'm citing for the court that says the jurat, that's the notary's jurat that they put on there, and it says a jurat is the official statement that the document was sworn and subscribed to before the officer. I literally, I'm dumbfounded as to how this is supposedly not an oath when in fact, the Texas Court of Criminal Appeals has, or actually, I think that was, the Texas, Court of Appeals in San Antonio noted that a jurat is an official statement that the document was sworn and subscribed to before the, officer who took the oath. So it is sworn. Now let's look back. He's saying, well, he's not firmly bound. This is only appearance in the top part. That's not what it says. In the first sentence, it says that we, the undersigned principal and surety, are held firmly bound unto the state of Texas in the sum shown below. That right there puts the principal on the hook. The principal is swearing that he's bound to the state of Texas, not only to appear, but if he does not appear, then he is bound for the amounts shown below, which in this case is $5,000. So, you know, this under oath is absolutely a red herring. There is no, I mean, number one, it is under oath. I can't figure it out. In fact, it's interesting to note that the Texas Court of Criminal Appeals in the Hardy case versus state of Texas said that, or referenced the penal code relative to perjury and aggravated perjury, where the law says that a document, it is no defense to the prosecution under the perjury and aggravated perjury that a document was not sworn to if the document contains a recital that it was made under oath. You can't come in and say, oh, well, it's not perjury because, you know, you have to bring in somebody else. But whenever there's a jurat in there showing that it was sworn to, then you can't use that as a defense on your perjury charge because you swore to it at the time that you entered it. So literally the oath, like I said, is highlighted right there and taken by the notary. And so anyway, so it is taken under oath. Next, and he didn't address this on his argument, it says, but argues that the bond does not include the principal's mailing address. Number one, there's nothing in the Code of Criminal Procedure that he cited that would say that a bond is invalid if it doesn't have a address for the principal. Doesn't say that. But anyway, if it does, he certainly didn't cite it. I'll put it to you that way, Honor. But again, it's on the bond right there. Anthony Ray Gillian. Address is 2268 63rd Street, Fort Acres, Texas, 77640. So again, that's one of those mysteries of, you know, you just can't, you would have to ignore what your lying eyes are telling you because it's right there in front of you. Next, okay, again, and this goes back into what I was saying a moment ago. My paragraph 5 says principal swore that he was firmly bound under the state of Texas in the sum shown below, which was $5,000. So again, he swore to it. Next, now this is where it's real interesting. This is the part where he's then arguing that the principal must swear that he has assets subject to foreclosure that are at least twice the amount of the bond. And he cites for that proposition section 17.13. Well, if you look at section 17.13 of the Code of Criminal Procedure, I'll give the court a moment to get to that page.
Okay.
All right. It says that the requirements, if they're going to test whether or not the okay, yeah, this is his argument, is saying that you have to have that test in there that they're worth at least twice the amount. Looking at 17.13, it says to test the sufficiency of the security offered to any bail bond, and then I've skipped quite a few lines. Right at the end of it, it's that same paragraph. It says, the following oath shall be made in writing and subscribed by the sureties. Nowhere in there does it say that that has to be subscribed to by the principal. That's not the law. It's only the sureties have to say that they have twice the amount of money available for seizure under the Texas laws, it's not the principal. I mean, by its very wording, the very statute he cites disclaims what he's making that argument on. It's, in fact, it really, if the court were to cogitate it or think about it for a little while, literally what he's saying is that you could, a poor person that can't come up with, as in this case, $10,000 of assets that are subject to being foreclosed on, then they couldn't bond out of the jail by their attorney. They simply wouldn't be able to do that. And that's not the case. There is no requirement of the principal having to swear the same things that the sureties do. They don't have to swear that I am worth at least double the amount of the bond in order to bond out. And that's what basically Mr. Lane is arguing, that applies to each and every bond in this county, which that makes absolutely no sense at all. Poor people can bond out of jail if they've got people that will co-sign on the bond or whatever it takes to order to get a bondsman to post the bond. The last paragraph, again, he cites section 2213 again. No, there is no case law cited in his motion at all. None. And like I said, the 4 sections of the Code of Criminal Procedure that he does cite, 2213 says, yeah, if the bond's invalid, then that may be a basis for exoneration of the surety. But the bond's not invalid for every reason that he's argued that it, or for any of the reasons that he's argued that it is invalid. Like I said, the principal swore to it and is bound by it. So is the surety, and there's nothing invalid about this bond, Your Honor. And we'd ask that the court enter the final judgment in this case for the full amount of the bond plus court costs.
Matt, just a quick response.
Yes.
What the state is basically saying is that this top part of the bond, the appearance part, that's what I'm calling the top part of the bond, is an oath. It's not an oath. And when you say sworn and subscribed, that is the notary saying, I am swearing and subscribing that this is the principal, this is who this person says to be, right? Yes, his address is in that section, but there is no under oath section for the principal. That's why I said the principal must have his own section under oath that he is bound to this particular document. Listen, the principal's never bound to this particular document. Under the arguments of the state, there is never binding. You always go after the surety all the time. They placate by putting the principal's name in the petition. But at the end of the day, it's only the surety that they go after. Well, that's not the law. If you can't go after the principal, you cannot go after the surety. And without that oath by the principal that you are bound and that you can be sued legitimately under a lawsuit, then you don't have a valid bond sufficient to support a nisi. You may have a valid bond sufficient to support appearance, but you do not have a valid bond to support a nisi. And that was where 2213 came in. If you don't bind the principal and have the requirements that he be bound to this under oath, not an appearance, not a notary for appearance, under oath. And this is why Bell County wouldn't accept the bond, because they could never bind the principal because he never signed under oath that he could be bound, just the surety. But if you can never bind the principal by law, you can never bind the surety.
All I can respond, Your Honor, is exactly what I said. A jurat is a jurat. Literally, it says sworn and subscribed to before me on this other on this day. by the principal. I mean, that's what the document says.
Hmm.
It doesn't say that he didn't take an oath. There's no evidence that he didn't take an oath. It's just argument that apparently the only thing that the surety would argue in this particular case is at the top it should say oath on there, is what it should say. And if it said oath, then all of a sudden that jurat that's down there where it says subscribed and sworn to means something. Well, it does when you raise your right hand and you swear that this is true and correct, and you then sign the document that contains that information, you're swearing to it. And that's what the principal did in this case.
Okay. Now, I'm looking at the bond. It says attorney surety bond. In the first paragraph at the top, it says that we, the undersigned principal and surety, are held firmly bound unto the state of Texas in the sum shown below on the condition that the principal, who is now in custody of the sheriff of Jefferson County, Texas, for the offense shown below, will appear in stanza in all courts to which the cause may be transferred and remain to answer the accusation. We are also bound for the payment of all necessary and reasonable expenses incurred by the sheriffs and peace officers in rearresting the principal in the event that he fails to appear, and returning him to the sheriff's custody. This obligation becomes null and void when the principal is discharged of legal liability for such accusation in accordance with the law. Now, at the bottom, where at the jurat, it says sworn to and subscribed to before me by the principal on March 15th of 2022. And it says no republic for the state of Texas. And under that, it says attorney surety acknowledgement of bond. And the last word is oath. So it appears that the surety and the principal are bound, and that this is an oath.
So is the court saying that the top part is an oath to the principal?
It says the principal and surety. I mean, I'm looking at the document. I'm looking at the complete document
Right.
as a whole.
Yes, I mean, so
And
there's no top section where the surety signs this particular paragraph under oath, just that they're worth a certain amount at the bottom, which I'm saying the defendant should sign. In other words, yes, it should say oath, have the surety and the principal sign, and the first sentence should be under oath with the rest of it. So, but that's not the way this is set up.
I'm saying it's I guess you have two jurats, one where the principal, and then there's another one for the attorney. Now, are you saying that neither one of these are oaths?
I'm saying
Because
that
both of them are notarized by sureties. I mean, excuse me, by notaries.
yes, they're both notarized by
So
notaries, but that, yes, I'm saying that the first one is,
You saying the top is not an oath, but the bottom is an oath, and both are notarized by notary. Now, you said that the top
Yes.
one was not an oath because the notary, I guess in your words, just to a certain degree, saying couldn't take the oath.
right, that, I'm
So
saying that,
are they able to take the oath of the attorney? You
yes,
said that's just an oath. I mean, you got,
yes, the oath of the attorney should be similar to an oath for the principal. And that the wording, even though that we did read the Code of Criminal Procedure may not require you to be worth a certain amount,
yeah,
you still have to be put under oath that you
Okay.
are.
Let's look at the document. The oath that the attorney was put under stated sworn to and subscribed to before me by the said surety, and it has the date. And then the notary public signed it and stamped it.
Right.
Above, it says, where the principal signed, it says sworn to and subscribed to before me by the said principal, and it's dated and signed by the notary. So you're saying one is an oath, the other one is not an oath, and it's
That's what I'm saying. I'm saying that is not sufficient as an oath. It's
Okay.
sufficient as a appearance, but not as an oath.
okay.
Sworn to subscribe to, Your Honor, the Texas Court of Criminal Appeals.
Now you,
It's not a defense to perjury, once you have that jurat in there, and that's the case law that we cited for the court. Yeah, and that's literally the jurat is sworn and subscribed to me on this day, personally appeared, in this case, the principal.
now, Mr. Lane, do you have a case to support your position?
I don't, Your Honor. We need a little time to get that on the validity. I guess the issue the court is specifically asking me is the validity of a notary sufficient to somehow ascribe an oath for the principal to be bound to a certain amount of money. I don't have a case on that. Versus just an appearance, like that's my signature. That's
Do
the
you
person
have
signing it.
I'm just saying, I guess what I'm asking, do you have a case to support your arguments as it's laid out in the brief that you submitted to the court on the motion?
No, sir.
Okay.
I haven't.
Because I think the state response is in direct response to your motion in the brief that and I'm calling this a brief, it's titled motion
Yes, sir.
dismiss judgment, Nisi, and set aside bond. So that's what the state is responding to.
I know.
And I think your argument is actually based on this motion to dismiss judgment, Nisi, and to set aside bond.
I know.
So I was just wondering if you had any case law to support the arguments that you're making from your brief.
I don't at this point, Your Honor. I know that when you start an oath, you start by swearing. Normally, an oath, when you get on the stand and he talks about perjury, the reason that you get perjury is because you swear to tell the truth and the whole truth and nothing but the truth. That's the oath. That is what the surety does. That is not what the principal does. The principal, the sworn to, is the notary swearing that that's the principal. If I brought you in the court, can you identify who's the signature? That's why the clerk always do.
Okay.
So what I'm saying is, I could do some research on the law on the oath, but I don't believe that the number 1 paragraph is an oath to the principal. So I guess that's where I'm at.
Okay.
Your Honor, there's no difference between the oath that Mr. Lane took as a surety and the oath that the principal took.
Okay.
Both were, and as the court pointed out, sworn to and subscribed to before me by the said, one said principal, the other one said surety. That's an oath.
Okay.
I think that the language within the oath is different. It is different than the language in the first thing. It literally puts you under oath. That's what it does. So when the notary signs that this is you, this is Brian Lane signing the document, it puts the surety under oath because it says, I swear. There's nothing in the first sentence of this top paragraph that has anything to do with putting the principal under oath. I don't think that you can construe that as a firmly oath required paragraph. That is kind of the crux of my entire argument. You're not putting the surety under oath.
Okay, that's it?
Yes, sir.
Okay, well, I'm gonna deny your motion. Set aside, deny, to dismiss the judgment, Nisi, and set aside the bond.
All right, Your Honor, we
Okay.
will submit a final judgment for the court's entry.
Okay. Thank you.
Thank you, Your Honor.
Okay, you may be
dismissed.
excused. Yes.
Thank you.